On a Tuesday morning in Harwick Falls, Pennsylvania, a 17-year-old boy stood at the end of his driveway while police moved in and out of his house. And on his face, captured in perfect, damning clarity by his neighbor's security camera, was a smirk. Not grief, not fear, a smirk. His father was dead on the kitchen floor inside. The knife was in the sink, and Dylan Holt stood there with his hands in the pockets of his hoodie, watching the officers work, looking like someone who believed with complete and absolute certainty that none of this was going to touch him. He was wrong, and the person who would prove it to him was a 58-year-old judge who had seen everything except someone quite like him. Stories like this remind us that justice always finds its way. If you believe in accountability, if you believe that a smirk at a crime scene cannot be the end of the story, subscribe now and tell us what you think below. This is how it all began. Raymond Holt was 44 years old. He woke up every morning at 5:15 to make lunches for his 3 kids. He had calloused hands, and a laugh his co-workers said was the loudest thing on any job site. He had written his oldest son a letter, 3 handwritten drafts, apologizing for the man he used to be. That letter was found in his nightstand after his death. His son had never responded to it. And on this Tuesday morning in early autumn, while neighbors stood behind yellow police tape in their pajamas, holding coffee mugs they'd forgotten to drink from, that son was standing at the end of the driveway, watching, waiting, and wearing an expression that would be discussed in courtrooms and described in testimony for months to come. The investigation had already begun, and Dylan Holt had no idea what his neighbor's camera had already seen. On a Tuesday morning in Harwick Falls, Pennsylvania, a mid-sized Rust Belt city where oak trees were just beginning to surrender their leaves to autumn, nothing extraordinary was supposed to happen. The streets of the Pendleton Court neighborhood were quiet in the way that ordinary neighborhoods are quiet at dawn, filled with the small rituals of ordinary life. A sprinkler running on a front lawn, a recycling bin left at the curb from the day before, the distant sound of a school bus making its first loop of the morning. At 14 Pendleton Court, a beige colonial house with a back deck that its owner had built himself, a police cruiser sat at an angle in the driveway, its blue and red lights throwing cold color against warm siding. The front door was wide open, and inside that house, Raymond Holt, a 44-year-old father of 3, a man who had woken up at 5:15 that morning to the last morning of his life, was dead on the kitchen floor. The first responders had been called at 7:44 in the morning, summoned by a phone call that the 911 dispatcher would later describe in open court as one of the most unsettling she had received in her career. Not because the caller had said anything alarming, but because of what was entirely absent from his voice. There was no trembling. There was no urgency. There was no grief bleeding through the edges of the words the way grief always does when it is real and new and incomprehensible. The caller stated in a flat and even tone that his father appeared to be hurt, that he was in the kitchen, and that he needed someone to come. When the dispatcher asked whether the caller was safe, the voice said yes. When she asked him to stay on the line, he said he would. When she asked if he could tell whether his father was breathing, there was a brief pause, and then, "I don't think so." No follow-up question, no sound of movement toward Raymond. Just the declarative fact, delivered in a tone so measured that the dispatcher circled the call in her notes and flagged it for the responding officers before they even left the station. Standing at the end of the driveway when those officers arrived was Dylan Holt, 17 years old, junior at Harwick Falls High School, eldest child of the man now lying on the kitchen floor. And he was wearing a grey pullover hoodie with his school's name printed across the chest. His hands were in his pockets. He was watching the officers move toward the house with a detachment that the first officer on scene, Patrolman Craig Ellison, would describe in his incident report as remarkable for someone whose parent has just been found deceased. Dylan answered Ellison's initial questions briefly and cooperatively. He did not cry. He did not ask about his father's condition with any urgency. He stood at that driveway and he watched, and at the corner of his mouth, in a capture that would become the most discussed image of the entire case, was the faint but unmistakable upward pull of a smirk. That smirk was preserved in permanent digital record by the Ring doorbell camera mounted on the porch of Patricia Nguyen's home directly across the street. Patricia had installed the camera 3 months earlier, after a string of package thefts on the block, and had not thought much about it since. She had certainly not imagined that it would become a primary piece of evidence in a first-degree murder trial. But the camera had been recording since 11:47 the previous night, and what it had captured was a comprehensive record of everything that happened at the front face of 14 Pendleton Court across those critical hours, including Dylan leaving through the front door at 11:52 in the evening, returning at 12:09 in the morning, and standing at that driveway 8 hours later with an expression that no grieving child wears. And it had captured something else, something that investigators would not fully appreciate until the county's digital forensics unit enhanced the footage at 400% zoom. A faint, rust-brown smear on the right cuff of Dylan's hoodie. A smear that would turn out to be his father's blood. Detective Aaron Briggs arrived on scene at 9:15 and was briefed by Ellison within minutes. Briggs had spent 22 years working domestic homicides in this county, and he had developed what his colleagues described as an almost uncomfortable patience, the ability to sit in the presence of evidence and let it tell its story without rushing to a conclusion. What the kitchen told him on his first walkthrough was a story with an architecture he had seen before. Not the chaos of a panicked, unplanned attack, but something more deliberate. 4 stab wounds, 2 of them with what the medical examiner would later characterize as deliberate downward pressure. A knife found rinsed in the sink. A crime scene that, on its surface, gestured towards struggle, but, on closer inspection, revealed itself as something more carefully arranged. Briggs walked through it twice. On his second pass, he took a photograph of the knife block, 4 knives in their slots, 1 empty, and made a note in his pad. Chosen, not grabbed. Raymond Holt had been stabbed 4 times in his own kitchen, on the hardwood floor he had installed himself 12 years before. He had last been seen alive by his family on Sunday evening during an argument about a curfew. On Monday night, his wife Sandra had made pasta for the family, and the pan was still in the drying rack beside the sink when officers arrived on Tuesday morning. Raymond had been sober for 6 years. He had attended his youngest son Connor's soccer game the previous Saturday, cheering in a green windbreaker on the sideline. He had been to 2 parent-teacher conferences that semester. He had been trying, in every documented way available to him, to be the father he had not been when his children were small. And someone had stood over him on the kitchen floor and made a choice that ended all of it. In the hours after the discovery, as Dylan sat in a plastic chair at the county precinct, answering questions from Briggs, in a tone that investigators found deeply unsettling, the digital forensics team was already analyzing Patricia Nguyen's footage frame by frame. The county prosecutor's office had been called. The DNA lab had been put on standby for the hoodie. And somewhere across town, in a courthouse that smelled of old wood and institutional floor wax, a judge named Margaret Calloway was being briefed on a case that would, in the months ahead, force her to make a decision that no judge takes lightly. A decision that Dylan Holt, sitting in that precinct chair and asking whether he could have something to eat, never once imagined was coming. The smirk had lasted only a moment at the driveway. It would last, in evidence and in memory, for the entirety of what followed. Because evidence has no loyalty. And justice, as Harwick Falls was about to discover, has very long sight lines. Raymond Holt was not a complicated man, and the people who loved him will tell you that was one of his greatest qualities. He was 44 years old, broad-shouldered from 2 decades of construction work. With calloused hands and a laugh, his co-workers described as the loudest thing on any job site. He had grown up in Harwick Falls himself, attended the same high school his children now attended, and after a brief attempt at community college in his early 20s, he came back to the town he knew, found work, found love, and built a life. It was a modest life by some measures. It was, by every measure that mattered, a real one. He knew which neighbors needed their driveway shoveled before they asked. He knew how his youngest boy liked his sandwiches. He knew, by year 6 of his sobriety, that being present was not a gift you gave your family once. It was a practice, daily and deliberate, that you chose again every morning. Raymond had been married to Sandra Holt for 19 years. They had 3 children, Dylan, 17, Mia, 14, and Connor, who had just turned 9 and still believed his father hung the moon. Sandra worked as a dental hygienist on Elmwood Avenue, and she described their marriage in the measured language of someone who understood its full complexity. Not perfect, but theirs. They had been through difficult years, financial pressure, Raymond's drinking problem in his mid-30s, a period of counseling and genuine strain. But by the time of his death, and their family's former therapist would testify that Raymond had made documented, verified, sustained progress. He had been sober for 6 years. He had completed a full course of cognitive behavioral therapy. He had changed. Not in the shiny, unexamined way that people sometimes claim to change, but in the slow, documented, witnessed way that change actually works when it is real. Raymond's relationship with Dylan was the most complicated thread in the family tapestry. And it was a thread that both the prosecution and the defense would pull at throughout the proceedings. Raymond had been a harder, angrier version of himself during Dylan's early years, the drinking years, and the shadow of that period had never fully left Dylan's memory, despite everything Raymond had done to earn a different story. Marcus Webb, Raymond's best friend and co-worker, described it plainly in his testimony. Ray spent years trying to make it right with that boy. He'd drive him to school. He'd go to every game. He wrote him a letter, an actual handwritten letter, apologizing for the man he used to be. Dylan never responded to it. The letter was found in Raymond's nightstand drawer. It had been written and rewritten 3 times. The final draft was dated 11 months before Raymond's death, and its last line read, "I'm not asking you to forget. I'm asking you to see who I'm trying to be." The house at 14 Pendleton Court had been purchased by Raymond and Sandra 8 years earlier, and Raymond had renovated most of it himself. The kitchen cabinets, the back deck, the hardwood floors in the living room that were now the floor his body was found on. Neighbors described the Holts as quiet, ordinary, and kind. Patricia Nguyen, directly across the street, remembered that Raymond shoveled her driveway twice every winter without being asked. "He'd just do it," she said. Not because he wanted anything, just because that was who he was by then. That observation, by then, contained a whole history inside 2 words. It acknowledged that Raymond had been someone different once, and that he had chosen, through sustained and difficult effort, to become someone else. The community knew both versions of Raymond Holt. They mourned the second one. In the 7 days before his death, Raymond had done nothing unusual. And he worked a full week on a commercial foundation pour in the next county. He attended Connor's soccer game on Saturday afternoon. He argued with Dylan on Sunday evening about a curfew, witnessed by Sandra and Mia, described by both as loud but not violent, the kind of argument that families have and move past. On Monday night, he made pasta for dinner, garlic bread on the side, the kind of meal that leaves warmth in a kitchen long after the plates are cleared. And he watched television with Connor afterward. He went to bed. The garlic bread pan was in the drying rack when officers arrived the next morning, as mundane and domestic a detail as any in the entire case record. A man's last evening of ordinary life, preserved in a clean pan beside a sink that now held a rinsed knife. Raymond's transformation had been genuine, and the prosecution worked carefully to establish this, because the defense's strategy would rely heavily on who Raymond used to be. Like his former therapist, Dr. Angela Marsh, testified that Raymond had confronted the worst part of himself and chosen differently. Those were her words, and she said them with the precision of someone who had watched the process in real time. His sobriety group leader confirmed 6 years of consistent attendance. His children's school record showed an increasingly active paternal presence during those years. Permission slips signed, parent-teacher conferences attended. The school's booster club joined in the fall before his death. Raymond Holt, at 44, was not the man Raymond Holt had been at 34. The evidence was unambiguous about that. The tragedy was that it was equally unambiguous about everything else. When news spread through Harwich Falls that Raymond was gone, the response was immediate and genuine. Flowers and candles appeared at the end of the Pendleton Court driveway by afternoon. His construction crew took a day off work. The company owner posted online, "We lost a good man today. Not just a good worker, a good man." Sandra was at the hospital when she received the call, having taken Connor to a routine checkup. Mia was in school. Raymond's older sister Diane drove 8 hours from Ohio and sat in Sandra's kitchen that night, unable to eat, unable to stop thinking about the Sunday phone call she had made to Raymond 3 days before his death. He had answered on the second ring. He had been laughing about something Connor had said. She had told him she loved him. He had said it back. It was an ordinary conversation. She would replay it for the rest of her life. The question of what actually happened inside that kitchen, the sequence, the words, the moment everything turned, would be contested for months. Dylan's version would be offered once, then revised again, and then contradicted by 4 pieces of physical evidence and 1 piece of digital evidence so clear and so precisely dated that when the prosecution displayed it on the courtroom screen, audible gasps rose from the gallery. Raymond Holt deserved better than to be the subject of a criminal case. But he also deserved what the law has to offer: the systematic, documented, argued, and formally decided accounting of what was done to him and by whom, and with what intent. That accounting was coming. It would begin, as all such things do, with what was left behind. On the floor, in the sink, on a cuff, and in the permanent, unblinking memory of a neighbor's camera that had recorded everything. Lead crime scene investigator Dana Price arrived at 14 Pendleton Court at 8:22 in the morning, 38 minutes after the first officers secured the scene. Dana was 17 years into a career that had taken her through hundreds of domestic crime scenes across the county. And in those years, she had developed a particular discipline. She did not allow herself to reach conclusions on first entry. She walked in, she observed, she documented, and she let the scene speak before she decided what it was saying. What the kitchen at 14 Pendleton Court said to her over the course of her first full walkthrough was something she would later describe in testimony as one of the most architecturally deliberate domestic scenes I have encountered. Not the most violent, not the most complex, the most deliberate. That word, deliberate, would echo through the trial for months. Raymond Holt was lying on his back at the base of the kitchen island, a large freestanding wooden block that Raymond had built and installed himself. He had been stabbed 4 times, 2 wounds to the upper abdomen, 1 to the lower left chest, 1 to the right shoulder. There was significant blood pooling beneath him and arterial splatter on the lower cabinet doors to his left. What was notably absent was the chaos that typically characterizes an unplanned, reactive attack. The overturned furniture, the scattered objects, the random distribution of impact marks that tells the story of a space being used desperately. This kitchen told a different story. Its disorder was contained, specific, and, Dana Price would come to believe over the course of 2 walkthroughs, selectively arranged. The weapon was found in the kitchen sink. It was a 9-inch boning knife from the Holt's own knife block, which sat on the counter to the right of the stove. The knife had been rinsed, not professionally, not thoroughly, but rinsed in the way that someone does when they are in a hurry, or when they believe that a cursory cleaning will be sufficient to remove the worst of the evidence. CSI Price noted this in her report with clinical precision. The presence of a rinse indicated post-offense awareness and action, which was inconsistent with a panicked or entirely reactive offender. The knife block itself still held 4 other knives. Only the boning knife was absent from its slot. It had been selected, used, and then returned to the vicinity of the block, not replaced in it, but placed in the sink, as if in a gesture toward normalcy that stopped just short of completion. Using luminol and alternate light sources, Price's team mapped the full blood trail across the kitchen floor over the course of the morning. What emerged was a picture of movement. Raymond had been standing near the refrigerator when the first blow was delivered, had moved or been pushed toward the island, and had gone down near its base after the 3rd or 4th strike. There were no blood tracks leading out of the kitchen through the main entrance, which meant the person who had stood over Raymond had exited either by avoiding the blood pool entirely or by using the side utility door, a door that opened onto a small porch on the back corner of the property, in the one area that Patricia Nguyen's camera angle did not reach. That door had been closed but unlocked when officers arrived. It became, in Price's investigation, a significant detail. The back door as exit strategy, the camera blind spot as geographic knowledge. When Detective Briggs approached Dylan at the driveway that morning, Dylan was wearing the grey Harwick Falls High School hoodie. Briggs noted that Dylan was calm, cooperative, and what Briggs would later describe as unusually talkative for the circumstances, asking questions about the investigation's timeline, volunteering context about family dynamics, performing the role of a helpful bystander with a fluency that experienced officers found off-register. Briggs requested the hoodie as standard protocol, and Dylan hesitated, 2 seconds barely perceptible, before removing it without protest. The smear on the right cuff was visible to the naked eye at close range, a rust-brown stain approximately 4 centimeters long, dried and consistent in color and texture with blood. When Briggs asked about it, Dylan said he'd cut himself earlier in the week. The explanation was delivered without hesitation. The lab would dismantle it within 4 days. One detail that investigators documented, but did not immediately interpret, was the state of the kitchen counter adjacent to the knife block. On that counter were 2 items that seemed inconsistent with the scene's timeline: Raymond's phone, placed screen down, and a folded piece of paper. The paper turned out to be a printed hardware store receipt dated the day before Raymond's death. A receipt that had, in all likelihood, arrived in Raymond's pocket and been left on the counter in the ordinary way that receipts end up on counters. But someone had picked it up, turned it to its blank side, and written on it in ballpoint pen 4 words: "Don't push me again." The handwriting was not Raymond's. A forensic analysis later confirmed it matched Dylan's handwriting samples from school with 94% certainty. The note was not dated. It was not signed, but it had been written, placed on the counter, and left beside a dead man's silenced phone. And in the context of everything else the kitchen had to say, it functioned less like an afterthought and more like an announcement. The medical examiner, Dr. Franklin Osei, placed Raymond's time of death between 1 and 3 in the morning. This was critical for a reason that would become central to the prosecution's case. Dylan had told the responding officer that he had last seen his father alive at approximately 10:30 the previous evening, and when Raymond had gone to bed. The neighbor's camera had shown Dylan re-entering the house at 12:09 in the morning. If Dr. Osei's window was accurate and he was prepared to defend it with core body temperature data, liver temperature readings, and lividity analysis against 3 hours of cross-examination, then Dylan was not simply in the house when Raymond died. He was one of the last living people to have been with Raymond. His stated timeline was not a gap or an inconsistency. It was, the prosecution would argue, a lie, and a lie constructed to place himself outside the window of death by nearly 2.5 hours. The most significant forensic finding, however, was something Dana Price did not fully articulate until her second walkthrough of the scene. Evidence of staging. A chair had been knocked over, but in the wrong direction, toward the island rather than away from it, inconsistent with the blood trail's implied movement. A glass on the counter had been tipped, but luminol revealed no liquid dispersion pattern beneath it, meaning it had been tipped after the fact, without anything inside it. These were small stagings, imperfect, the kind of attempt that someone makes when they want a scene to read as a sudden reactive conflict rather than a planned one. Price's conclusion in her final report was careful and precise. The physical evidence in this kitchen reflects an attempt to simulate spontaneous conflict rather than document it. By late afternoon, the team had bagged 47 pieces of evidence, collected DNA samples from 6 locations, and submitted the hoodie for expedited lab testing. Dylan, in the precinct, had not once asked about his father. The camera had recorded everything. The lab was waiting. And the investigation that Dylan believed he had already outrun had not yet fully begun. Dylan Holt had, by every observable measure, been an unremarkable teenager. He was a junior at Harwick Falls High, carrying a 3.1 GPA, and he had played on the school's junior varsity baseball team through his sophomore year before quitting without explanation. His teachers described him in the familiar terms that fill unremarkable report cards: quiet, occasionally distracted, smart when he applies himself. He had a loose group of friends who gathered at the town's one remaining diner on weekend evenings, a girlfriend named Kayla, and a bedroom wall with the kind of posters that say more about a person's aspirations than their interior life. Nobody who knew Dylan casually would have predicted what was found on a Tuesday morning at 14 Pendleton Court. That was, in many ways, the most disturbing dimension of the entire story. Not the crime, but the ordinariness of the person who committed it. Beneath the surface, those who knew Dylan more closely described something different. His baseball coach, Tom Lester, remembered having to remove Dylan from the dugout twice for reactions he described as disproportionate to the moment. Once for throwing a bat against the wall after a strikeout, once for screaming at a teammate in terms that Lester said were genuinely alarming for a 15-year-old. Dylan's school counselor, a Patricia Ullman, had flagged him twice in 2 years for emotional regulation concerns and had recommended psychological evaluation both times. Neither recommendation had been followed through. Sandra later testified she had been in denial about the severity of what she was seeing, a confession she made on the stand with visible self-recrimination. Dylan had also been involved in 2 physical altercations on school property, neither of which resulted in formal suspension. Each time, and the system had found a reason to stop short of escalation. Each time, Dylan had moved forward without consequence. The relationship between Dylan and Raymond was, according to everyone who witnessed it, a fire that had never found a safe container. Raymond's past was real and painful, and its impact on Dylan was real and documented. The defense would use this history at every opportunity throughout the trial, and they were right to use it. Because it was true, and it mattered, and it deserved to be heard. But the tragedy at the center of this case was not that Raymond Holt was a monster who was killed by his traumatized son. The tragedy was that Raymond Holt had genuinely changed, and that his son, who carried the memory of the old Raymond without the experience of the new one, had built a fixed and permanent narrative in which his father remained the threat, regardless of who Raymond had actually become. Dylan had a map drawn in fear and drawn in 2013, and he had never once updated it. Updating it would have required something Dylan appeared constitutionally unable to do: admit that he had been wrong about someone he had organized his entire emotional landscape around being afraid of. Detective Briggs obtained a warrant for Dylan's phone records on the afternoon of Raymond's death. What he found, texted to Kayla over the previous 6 weeks, was a mounting record of escalating hostility directed at Raymond. The messages began with ordinary teenage complaints, frustration about grades, irritation about perceived surveillance, and moved, week by week, towards something with a different quality entirely. "I can't stand being in this house with him," arrived in early September. "I think about it sometimes, just making him stop," came 2 weeks later. And then, at 11:44 on the night of Raymond's death, 8 minutes before Dylan appeared on the neighbor's camera leaving the house, a single message to Kayla: "Tonight, I finally did something about it." Briggs read that message on a screen in the county precinct while Dylan was sitting in a plastic chair 3 rooms away, asking for something to eat, and Briggs made a note beside it: "Sent before departure." Not after. Before. Kayla Wren received that text and did not contact any adult. She replied, "What the fuck? What did you do?" and received no response. She claimed in her initial interview that she had assumed Dylan meant something mundane, a slammed door, a raised voice. But the digital forensics team had recovered 14 messages deleted from Kayla's phone in the 48 hours after Raymond's death. including one in which Dylan offered a version of events, casting himself as defending himself against Raymond's aggression. One in which he explicitly asked Kayla not to tell anyone about the 11:44 text, and one sent at 2:17 in the morning within the medical examiner's confirmed window of Raymond's death, containing a single word: done. Kayla was not charged with any offense, but she would become one of the most emotionally significant witnesses of the trial, and her testimony, delivered with visible fear and visible regret in equal measure, would land in the courtroom with the specific weight of someone who understood too late what she had been part of. In his first formal interview at 11 o'clock that morning, Dylan told Briggs that he had gone to bed at 10, heard nothing unusual, and come downstairs at 7:30 to find his father on the floor. He was calm throughout. He made eye contact with consistency. He caught himself using the present tense when referring to Raymond, and corrected it without being prompted. He asked whether the investigation would take long. He said, and this was on the recording, "I want to be helpful. I really do." Briggs nodded and wrote in his notes, "Controlled performance." 22 years of domestic homicide investigation had given Briggs a precise internal instrument for distinguishing grief from its performance, shock from its simulation, and genuine cooperation from the simulation of cooperation, while simultaneously managing a narrative. What he was observing in that interview room was the third thing in every category. A deep background review, pulled by the prosecution's investigative team, revealed something that had not yet been publicly known. 2 years before Raymond's death, Dylan had been the subject of a concern report filed by his teacher, Mr. Gerald Cam, who reported that during a private conversation after class, Dylan had told him he had thought about what it would feel like to really hurt someone. Cam had filed the report with the school counselor's office. The counselor had logged it. No one had escalated it to law enforcement. The document had sat in a file for 2 years, unread by anyone with the authority to act on it, and Raymond Holt was, in some precise and devastating measure, the consequence of that inaction. When the prosecution introduced this document at trial, the courtroom went completely still. Not because it proved what Dylan had done, but because it proved how long the warning signs had been visible and how thoroughly everyone around Dylan had found reasons to look the other way. By the time detectives had assembled Dylan's full background, the behavioral flags, the school incidents, the escalating texts, the teacher's concern report, the camera footage, a portrait had formed that was deeply uncomfortable to look at directly. Now, not because Dylan was an obvious, identifiable danger, but because he was an ordinary-seeming boy who had been moving through every warning system available to him for years, and every system had bent slightly rather than held firm. The question this case would force, the question Judge Calloway would eventually address from the bench with extraordinary directness, was not only what Dylan had done, but what had been left undone in the years before that kitchen. The investigation, however, was not finished. Dylan had been served notice that the evidence against him was serious, and Dylan, characteristically, had already decided that his response was to build a better story. He did not yet know that his story had already been told by a camera, a phone, a kitchen, and his own handwriting, and that none of those narrators could be coached. And the Harwich Falls Police Department assigned Detective Aaron Briggs as lead investigator with forensic support from the county lab and digital forensics contractor Elise Munro. Briggs was 46, methodical and patient, the kind of detective who had built a career on sitting with difficult evidence until it chose to speak, rather than forcing it into a conclusion. Elise Munro was brought in specifically for the phone and camera data. She was contracted across 3 counties in the region and had a reputation for recovering evidence from devices that defense teams had assumed were clean, finding in digital residue the things that people most needed to believe they had erased. Together, over 11 days, they would build a case against a teenager who believed, with breathtaking sincerity and genuine confidence, that he had thought of everything. The gap between what Dylan believed and what the evidence contained was the gap into which the entire prosecution would walk. In the 72 hours following Raymond's death, while Dylan remained in juvenile detention pending a detention hearing, he continued to do something that investigators found remarkable. He tried to manage the narrative from inside the facility. He made 3 phone calls from detention, all recorded, as is standard practice, to friends from school. In each call, he described the investigation as overblown, said the police don't have anything real, and in one call told his friend Marcus Yates that he was not even stressed about it. He asked Marcus to tell people at school that Raymond had been troubled for a long time, and that everybody knew it. He was, in effect, running an informal public relations operation from a detention facility telephone while his father's blood was being analyzed at the county lab. And the recordings of these calls would become, in Chen's hands at trial, among the most damaging pieces of evidence in the entire case. Not for what they proved about the night of Raymond's death, but for what they proved about the person Dylan was in its aftermath. The DNA results from the hoodie cuff arrived on the 4th day of the investigation. The blood on Dylan's sleeve was Raymond Holt's, the statistical match reported by the lab as 1 in 1.3 trillion. The explanation Dylan had offered, that he had cut himself earlier in the week, was, of course, demolished. The blood was his father's, not his own. When Briggs presented this to the prosecutor's office, a full arrest warrant for first-degree murder was authorized. But Briggs made a decision at this point that would prove to be one of the most productive of the entire investigation. He requested that the warrant not be executed immediately. He wanted to let Dylan continue making calls from detention. He wanted to see what else Dylan said while he still believed himself ahead of the evidence. The phone rang. Dylan talked. The recorder kept running. Briggs waited. Elise Munro completed her extraction of both Dylan's and Kayla's cloud-backed data on the 6th day. The 14 deleted messages from Kayla's phone included the partial account of events Dylan had sent her in the 48 hours after Raymond's death, and the explicit instruction not to share the 11:44 text and the single-word message, done, sent at 2:17 in the morning within the medical examiner's confirmed window, Monroe printed the recovered messages, placed them in a labelled evidence sleeve, and handed them to Briggs without commentary. The word "done" appeared at the top of the printout, on a page that Briggs would carry in the evidence file for months, and ultimately hold up in courtroom 4 before a jury of 12 people who would not forget it. The handwriting analysis of the note, "Don't push me again," was confirmed as Dylan's with 94% certainty. More significantly, the examination revealed that the note had been written on the back of a hardware store receipt that had been in Raymond's possession. A receipt from a Saturday purchase, meaning it had arrived in the kitchen through ordinary household means. Dylan had picked it up at some point before the night of Raymond's death, turned it over, and written his warning on the blank side. Then he had placed it on the counter 2 feet from the knife block and left it there. The note was not a moment of anger scrawl. It was placed. It was deliberate. It was, in the prosecution's framing, an announcement, the kind that someone makes not in a moment of explosion, but in the cold, the planning state of someone who has already decided and is waiting for the occasion. On the 7th day, Briggs conducted a formal interview with Sandra Holt, who had been staying with her sister since the night of Raymond's death, existing in the particular anguish that only a person who has lost both a partner and a child can understand. Grieving Raymond and terrified for Dylan, and consumed by guilt about both simultaneously. She told Briggs about the Sunday argument, and about Dylan's behavioral history, about the evaluation referrals she hadn't followed through on. And then she told him something she had not yet told anyone, that on Monday evening, the night before Raymond's death, she had heard Dylan's voice through his bedroom wall, not on the phone, not directed at anyone visible, in a low, even tone, as if rehearsing something. She could not make out the words. She had thought nothing of it at the time. She had knocked on his door to say good night, that he had said good night back. She had gone to bed. It was the last ordinary thing she had done in her family's life before it ended. On the 8th day, Briggs conducted a second formal interview with Dylan, with defense attorney Richard Hale present. Briggs laid out the evidence sequence, the camera footage, the DNA results, the time of death discrepancy, the texts, calmly, methodically, without theatrics. Dylan's attorney advised him not to respond. Dylan didn't. But Briggs watched Dylan's face throughout the presentation, and what he observed was not fear or shock or remorse. What he observed was recalibration, the eyes of someone who is not hearing news, but is rearranging a story, testing different architectural configurations, looking for the version that still holds. In the hallway afterward, Briggs told the prosecutor, "He's already building a new version. We need to make sure the evidence is airtight before he finishes building it." The prosecutor nodded. The evidence was airtight. Dylan was still building. By the 11th day, the prosecution case was structurally complete. DNA evidence, digital evidence, the handwritten note, the time of death discrepancy, the staged crime scene analysis, and the recorded calls from detention. But the case was now approaching a question far larger than the evidence itself, a question that would divide legal opinion in Harwick Falls and generate coverage well beyond the county line. Dylan was 17. His offence, if proved, was severe and premeditated. But he was 17, and in Pennsylvania, that meant the question of how he would be tried was not automatic. It required a formal decision by the court. It required a specific kind of judicial reasoning. And it required Judge Margaret Calloway to look at everything the evidence contained and decide what it meant for a boy who had moved through 17 years of life with the unshaken belief that the rules that applied to everyone else had never quite applied to him. As part of the preliminary proceedings, Judge Calloway ordered a full psychological evaluation of Dylan Holt to be conducted by court-appointed forensic psychologist Dr. Serena Vance over 3 weeks. Dr. Vance had evaluated more than 200 juvenile defendants in her career and had testified in cases across 5 states. She was known in legal circles for reports that were thorough, honest, and deliberately resistant to manipulation by either side of a proceeding. Reports that said what the evidence supported and nothing more and nothing less. What she found over 3 weeks of structured interviews, psychological testing, and behavioral observation with Dylan Holt was, she would later say in testimony, one of the clearest pictures of adolescent narcissistic personality organization I have encountered in a forensic context. She was careful always to note that this was not a clinical diagnosis. It was a forensic framework for understanding the behavioral evidence. It was, she said, a way of accounting for what was otherwise very difficult to explain. Over 12 structured sessions, Dr. Vance administered the PCLYV, the MMPIA, and the Rorschach inkblot method. Dylan was, she noted in her preliminary findings, highly cooperative, verbally fluent, and consistently engaging, characteristics that, in her forensic experience, function as flags rather than reassurances. He told his story smoothly and consistently, without the normal hesitations and emotional interruptions that accompany genuine grief or genuine distress. He described Raymond's death as something that had to happen eventually during one session, a phrase Dr. Vance underlined 3 times in her notes and would quote verbatim in open court, where it landed in the gallery with the specific weight of a thing said out loud that cannot be unsaid. She was careful to contextualize it. She was thorough about context. But the phrase was what it was, and it had been said by the person who was most responsible for the thing that had happened. Dr. Vance's evaluation included a detailed developmental history drawn from school records, Sandra's testimony, and Dylan's own accounts. She described a boy who, during Raymond's drinking years, had built a coping structure organized around control and emotional self-insulation, mechanisms that were understandable and even adaptive for a frightened child, but that had calcified over years into something more rigid and more dangerous. Dylan had learned, in his earliest formation, that vulnerability led to pain. He had built walls. The problem was that as Raymond changed, as the danger those walls were built against ceased to exist, Dylan never dismantled them. He had a map of his father drawn in fear, drawn in 2013, and he had never updated it. because updating it would have required him to acknowledge that he had been wrong. And that was something Dylan appeared across all 12 sessions constitutionally incapable of doing. His self-conception was organized around a narrative of threat, and dismantling the threat dismantled the narrative, and dismantling the narrative dismantled something he had come to understand as himself. The most significant finding in Dr. Vance's report, the finding that would carry the most weight in Judge Calloway's decision, was the near total absence of remorse. Not the wrong kind of remorse, not misdirected or poorly expressed remorse, an actual, measurable, observable absence of it. When asked how he felt about his father's death, Dylan consistently redirected to justification. Raymond's past behavior, the Sunday argument, a sense of having been cornered. When asked directly, "Do you feel sorry that your father is dead?" Dylan paused for 6 seconds, the longest pause in any of their 12 sessions, and then said, "I feel sorry about how it looks." Not about what had happened to Raymond, about how it looked. Doctor. Vance wrote that sentence down and placed a box around it in her notes. In her testimony, she read it to the courtroom without emphasis or editorial, and the room received it in silence. Dr. Vance identified what she termed an entitlement architecture, a belief system built over years in which Dylan had come to understand himself as uniquely exempt from ordinary consequences. This manifested across the evidence record in consistent and compounding ways. The calm at the crime scene, the casual phone calls from detention, the performance of cooperation while managing the narrative in interviews, the smirk on the driveway. Dylan had never encountered a consequence significant enough to recalibrate his core belief that he was different from other people. Every warning system in his environment had given way. The school had logged concerns and not escalated them. The psychological evaluations had been recommended and not pursued. And the teacher's concern report had been filed and forgotten. And so Dylan had moved through every structure designed to stop him, and nothing had stopped him, and he had come, rationally, almost logically, from within his own experience, to believe that nothing would. That belief was not arrogance in the petty sense. It was a conclusion drawn from evidence about the nature of his world. The problem was that the world was about to offer him a correction. In Session 8, Dr. Vance asked Dylan to describe his earliest memory of Raymond. He described in careful and articulate language a specific incident from age 6. His father losing his temper over a spilled drink at dinner, the sound of it, the feeling of it. It was a real memory and a painful one, and Dr. Vance documented it with full empathy. Then she asked for his most recent memory of Raymond, from the weeks or months before his death. Dylan paused. Eventually, he described Raymond sitting at the kitchen table on a Saturday morning, reading the newspaper with Connor on his lap. It was, Dr. Vance noted in her report, an image of a man at peace, a man who had done the work and arrived somewhere quieter. Dylan had been unable to see it that way. He had looked at that scene, a father and his youngest child, a Saturday morning, a newspaper, a kitchen where someone would soon be dead, and seen something he wanted to erase. That was the distance between who Raymond had become and who Dylan had decided Raymond would always be. The defense's strategy built around a real legal theory that Dylan had acted in response to a documented history of harm, that his actions were the product of accumulated trauma rather than premeditated choice. It was not a dishonest argument. It had genuine application in other factual scenarios. The problem was that it did not fit the facts here. The staged crime scene, the handwritten note, the planned text messages, the post-offense behavioral management, and the calm, consistent, controlled presentation across every setting from the driveway to the precinct to the detention facility were not consistent with a trauma-driven reactive response. They were consistent with planning. And Dr. Vance, in her testimony, said what the evidence required her to say, that planning was not trauma. Planning was choice. And choice in a courtroom has a name. Dr. Vance concluded her evaluation with a formal recommendation that Dylan Holt be tried as an adult, citing the severity of the offense, the premeditation evidence, and the absence of remorse as critical factors in assessing rehabilitative potential within the juvenile system. The recommendation was not binding. It was one input among several, but in the courthouse hallways, among attorneys who understood how much weight Judge Calloway typically gave to court-appointed evaluations, the feeling was clear. Dylan's own psychology had become his most damaging witness. He had spent months performing composure as armor. Dr. Vance had turned that composure into evidence. And in courtroom 4, where the transfer hearing was now scheduled, the judge was ready to hear everything. In Pennsylvania, the decision to try a juvenile as an adult is not automatic, even in homicide cases. It requires a formal transfer hearing in which the court weighs a set of statutory factors: the severity of the offense, the minor's history, the availability of rehabilitative services within the juvenile system, and the threat posed to public safety. The hearing is designed to be deliberate because the decision is consequential in both directions. A finding that a juvenile should be tried as an adult carries implications for sentencing that can define the entirety of a young person's life. And a finding that they should remain in the juvenile system carries implications for the community's safety that can last just as long. Judge Margaret Calloway understood this weight, had always understood it, and presided over Dylan Holt's transfer hearing on a Wednesday morning, 6 weeks after Raymond's death, with the specific gravity of someone who has never once treated a human life as an administrative matter. Judge Margaret Calloway had been on the bench in Harwick Falls for 14 years. She was 58, precise in her language, and formidable in her reasoning, and attorneys across the county described her as possessing an almost supernatural ability to identify the moment testimony shifted from memory to construction. She had presided over 11 juvenile transfer hearings in her career and had granted adult transfer in 7 of them, a record that reflected neither consistent harshness nor consistent leniency, but rather a judicial philosophy she had articulated more than once in written opinions: that the law existed to serve the community's safety and the individual's possibility simultaneously, and that the hardest cases were the ones in which those two values pointed in opposite directions. A Dylan Holt's case, she would later write in her sentencing memorandum, was among the hardest of my career for precisely that reason. Assistant District Attorney Jennifer Chen opened the transfer hearing with 17 minutes of tight, evidence-based argument. She walked the court through the DNA evidence, the text messages, the handwritten note, the time of death discrepancy, the staged crime scene analysis, and the recorded calls from detention. She cited Dr. Vance's evaluation and its recommendation for adult transfer. She was precise and controlled throughout, and she ended with a statement the gallery would remember. The question before this court is not whether Dylan Holt had a difficult childhood. The evidence suggests he did in some respects, and the state does not dismiss that. The question is whether a 17-year-old who planned, executed, and then managed the narrative of his father's death is appropriately served by a juvenile system designed for very different cases. We submit that he is not. The courtroom was quiet after she sat down. The kind of quiet that follows a statement that has arrived with its full weight intact. Richard Hale argued with genuine passion for the juvenile system's capacity to address Dylan's needs. He referenced Dylan's academic record, his community ties, his age, and the substantial body of developmental science around adolescent brain function that has, over 2 decades, increasingly influenced how courts approach juvenile crime. He brought in his own expert, Dr. Thomas Ackerman, an adolescent development specialist, who testified about the neurological immaturity of the adolescent prefrontal cortex and the limits this places on impulse control and long-term consequence processing. It was a well-constructed argument, genuinely supported by science, and it deserved serious consideration. But it ran, throughout, into a fundamental problem. The physical evidence in this case did not read like impulse. The handwritten note, the premeditation marker texts, the staged scene, the managed post-offense behavior. None of it read like the product of a brain that had failed to calculate consequences. It read like the product of a brain that had calculated them and decided to proceed anyway. During the 3 days of the transfer hearing, Dylan sat at the defense table and watched the proceedings with an attentiveness that observers found almost performative in its evenness. He leaned toward his attorney to whisper at regular intervals. He wrote on a legal pad. He showed no visible emotion when forensic evidence was described, no flinch when the text messages were read aloud, and no change in expression when Dr. Vance quoted his own words back to him from the stand. "I feel sorry about how it looks." In a courtroom where those words had now been repeated publicly for the 2nd time. Several gallery observers noted that during that moment, Dylan turned very slightly toward the press section, as if checking whether the reaction was being captured. It was. The court reporter noted it, and so did Judge Calloway from the bench, but with an expression that those who knew her recognized as the particular stillness that preceded her most precisely worded observations. Sandra Holt took the stand on the 2nd day of the transfer hearing and occupied the most impossible position available to any witness in any courtroom. She was both the victim's widow and the defendant's mother, and she was there in both capacities simultaneously. She testified about Raymond's past, about Dylan's behavioral history. It's about the evaluation referrals she had not followed through on. She wept twice. When asked what she wanted for her son, she said, with a steadiness that cost her visibly, "I want him to get the help he needs, and I want him to understand what he did. I don't think he does yet." She paused. "I think that scares me more than anything else." In the gallery, Marcus Webb, who had come to every day of the hearing in his construction jacket, pressed his fist to his mouth and looked at the floor. The legal standard at the center of the transfer hearing was amenability to rehabilitation, a phrase that sounds clinical, but is, in practice, a deeply human question. It asked the court to make a judgment, not just about what Dylan had done, but about who he could become, given the right interventions, the right environment, and the right amount of time. Judge Calloway asked both expert witnesses pointed questions on this topic. To Dr. Vance, she asked, "In your professional judgment, is this defendant's absence of remorse a permanent feature of his psychology or a current state susceptible to change?" Dr. Vance paused. She said, "That is the most important question in this hearing, Your Honor, and I am not able to answer it with certainty. No one can." Judge Calloway nodded slowly. She wrote something down. She did not share what it was. At the close of the third day's proceedings, Judge Calloway did not issue an immediate ruling. She took the matter under advisement and set a date for her decision 2 weeks hence. In those 2 weeks, the case generated more public discussion than anything in Harwick Falls in recent memory. Debates in diners, in school hallways, on local forums, at community meetings about juvenile justice, about trauma and accountability, about what Raymond deserved and what Dylan was. And Dylan, back in detention, made more recorded calls. In one of them, captured and flagged and eventually played before a jury, he told a friend, "The judge has to give me a break. She's a judge. That's literally her job." He said it without irony, without doubt, with the complete confidence of someone who had never yet encountered a system that held. 2 weeks later, in courtroom 4, Judge Calloway would respond to that sentiment with extraordinary and permanent clarity. On a Thursday morning, 14 days after the close of the transfer hearing, Judge Calloway entered courtroom 4 at 9 o'clock precisely. The room was at capacity. Sandra was present, seated with her sister. Raymond's family had driven in from 2 other states. Press occupied every available seat in the gallery's upper section. The bailiff called for order. The room fell into the specific silence of a space where something irreversible is about to happen. Judge Calloway read her ruling in the measured, a deliberate cadence that those who knew her recognized as her most serious register. She found, based on the totality of the evidence presented, that the offences met the statutory criteria for adult transfer. She cited specifically evidence of premeditation, forensic staging analysis, post-offence behavioural management, and Dr. Vance's findings on the absence of remorse. Dylan Holt would be tried as an adult for first-degree murder. The decision was final. It was written. It was read aloud in a room full of people who would not forget it. When the ruling was read, Dylan Holt's face, that famously composed face, showed something new. Not fear, not sorrow, not the particular collapse of a person confronted with consequence. Something closer, by multiple accounts, to offence. The expression of someone who has been told they are not as exceptional as they believed, and who has not yet decided how to process that information. His attorney placed a hand on his arm. Dylan sat back. He looked briefly at the ceiling, a gesture the courtroom had seen before and would see again, and then looked back at the judge with an expression that a journalist in the gallery described in print the following morning as the look of someone who has decided the problem is the system, not themselves. It was a precise description, and it was a look that would define the months ahead with the consistency of a theme. Jury selection took 11 days. Jennifer Chen and Richard Hale both understood the specific emotional complexity this jury would need to navigate. A defendant with a sympathetic backstory, a victim with a sympathetic legacy, and physical evidence that was, in Chen's framing during voir dire, difficult to explain away without explaining the explanation away. Hale sought jurors with strong convictions about juvenile rehabilitation and adolescent brain science. Chen sought jurors who could separate emotional sympathy from legal fact-finding, a distinction she described, with characteristic precision, as the difference between feeling sorry for a person and deciding whether a specific set of acts met a specific legal standard. They seated 12 people with an average age of 41, including a former social worker, a retired police detective, a high school teacher, a small business owner, and 8 others who swore, as required, that they had formed no fixed opinions about either the defendant or the victim. The retired detective was juror number 7. He would remember everything. The trial of Dylan Holt, Commonwealth of Pennsylvania versus Dylan Holt, opened on a Monday morning in March, 7 months after Raymond's death. The courthouse on Elm Street was surrounded by a small crowd. Some held signs reading, "Justice for Raymond." One person held a sign reading, "Remember the child." Both sides had their adherents, and the division was genuine and uncomfortable, and said something true about the case, that this was not a situation with clean edges or a villain and a victim who fit the shapes those roles usually require. Inside, the courtroom felt more formal and more permanent than the transfer hearing had, more weighted with consequence. Dylan entered in a dark suit his attorney had selected, and he walked to the defense table with a posture that one reporter described as almost theatrical in its composure. He sat down. He folded his hands. He waited. Jennifer Chen's opening statement took 42 minutes, and it was, by all accounts, a masterclass in narrative construction. She walked the jury from the neighbor's camera footage to the knife in the sink, to the text messages, to the handwritten note. In each piece of evidence building on the last, with the accumulated logic of a structure that could only mean one thing once all its elements were present. She was careful, always, to acknowledge Dylan's difficult history. She said, "The state is not here to tell you Dylan Holt had an easy life. He did not. The state is here to tell you that what happened in that kitchen on that Tuesday morning was not a response to Raymond Holt's past. It was a decision about Raymond Holt's future, and Dylan Holt made that decision alone. She sat down. The gallery absorbed it. The jury wrote things on their notepads. Richard Hale rose. Hale's opening was 58 minutes and more emotionally textured. He spoke about Raymond's history in Dylan's early childhood, about specific incidents that Dylan had described to Dr. Vance, incidents that were painful to hear about and genuinely painful to have experienced. He described a child who had grown up in the presence of volatility and fear, who had never fully been able to trust that the stable version of his father was the permanent one. He acknowledged the evidence directly, with the confidence of a defense attorney who knows that transparent acknowledgement is stronger than evasion. Ladies and gentlemen, we are not here to tell you nothing happened in that kitchen. We are here to tell you what it meant, and what it means matters as much as what it was. It was a formidable framing, and it planted seeds of moral complexity that Hale would work to cultivate throughout the trial. The question was whether the physical evidence would allow those seeds to grow. Jury members interviewed after the trial's conclusion described their first impression of Dylan consistently, not what they expected. Several had anticipated someone visibly frightened, or someone whose behavior had the quality of disturbance, something that would explain the distance between an ordinary teenager and the events of 14 Pendleton Court. What they saw instead was a young man who sat at the defense table with his hands folded, watched the proceedings with careful attentiveness, and showed across the early days of the trial almost no emotional variation regardless of what was being said or shown. Juror number 7, the retired detective, who told a journalist after the verdict, "I've seen people who don't show emotion because they're in shock. I've seen people who've been coached into stillness. And I've seen people who don't show emotion because they genuinely don't feel it the way most people feel it. It took me a few days to form an opinion about which category this was." He paused. "I eventually did." By the end of the first week of trial, the prosecution had entered 31 exhibits into evidence and called 6 witnesses, including Detective Briggs, CSI Dana Price, and the 911 dispatcher, whose testimony about Dylan's emotionless phone call made audible impacts in the gallery. The defense had cross-examined each witness with competence and had found gaps in the evidence where gaps existed. Because there are always gaps, and a defense attorney's job is to find them and stand in them as long as possible. But on Friday afternoon of that first week, Jennifer Chen placed a single document on the exhibit table, a complete chronological printout of every recovered text message between Dylan and Kayla, and announced it would be addressed in full on Monday morning. Over the weekend in the detention facility, Dylan made 4 phone calls. He was not, this time, calm. Monday morning brought one of the most gripping stretches of testimony in the entire trial. Jennifer Chen presented the recovered text messages in their entirety, reading each one aloud in a voice that was deliberately flat, letting the content carry its own weight without editorial commentary from the person delivering it. She read from the early complaints through the weeks of mounting hostility, through the specific messages that named Raymond as a threat, and arrived, finally, at the two that had been circled in Briggs's notes from day one. Tonight, I finally did something about it. Sent at 11:44 on the night of Raymond's death. 8 minutes before Dylan appeared on the neighbor's camera leaving the house. And then, done. Sent at 2:17 in the morning within the confirmed window of Raymond's death. The courtroom was very quiet. 2 jurors wrote on their notepads at that moment. Juror number 7, the retired detective, wrote 3 words. He would not disclose what they were until after the verdict. He confirmed in a post-trial interview that they were the same 3 words he had written at the end of the first week of testimony when he had first read the messages himself. The video from Patricia Nguyen's camera was played for the jury on the second day of the second week. The courtroom watched the timestamps in real time. Dylan leaving through the front door at 11:52, returning at 12:09. The 17-minute window fell squarely within Dr. Osei's time-of-death estimate. But the most powerful moment was not the exit or the entry. It was what the camera showed in the interval between them, the 8 hours of footage that followed 12:09. The house sat still and dark. No one entered or left. The one available entrance in the camera's field of view remained undisturbed for 8 full hours, until the morning light came and a police cruiser pulled into the frame. Chen paused the playback when the footage reached 7:44 and said to the jury, 8 hours, 1 way in, no one else. She let that stand without elaboration. She had learned over years when evidence was better than commentary. Dr. Franklin Osei's testimony on time of death was the forensic backbone of the prosecution's case, and it withstood 3 hours of cross-examination without meaningful concession. He explained the methodology clearly. Core body temperature comparison, the role of the kitchen's ambient temperature as documented by responding officers, the calculation that placed Raymond's death between 1 and 3 in the morning. He acknowledged a potential margin of error of approximately 45 minutes in either direction. Even with that margin applied maximally, Dylan's re-entry at 12:09 placed him inside the house before the earliest possible moment of death. Hale, in Cross, pointed out correctly that 12:09 didn't prove Dylan was present at the moment of the offense. Chen, in Redirect, asked Dr. Osei a single question. How many people were recorded entering the house between midnight and 7 in the morning? Dr. Osei said, 1. The courtroom absorbed this with the stillness of people doing arithmetic. The handwritten note, "Don't push me again," was introduced through forensic document examiner Catherine Mills, who walked the jury through 15 specific letterform characteristics, matching Dylan's school-sourced handwriting samples, and through 5 additional structural patterns consistent with his known writing habits. She concluded with 94% certainty. Hale challenged the 6% margin on Cross. Mills acknowledged it. Chen, on Redirect, asked Mills a single question. In your professional experience, Here's 94% certainty, a high level of confidence for forensic handwriting analysis. Mills said, among the highest I would ever offer in a courtroom. The note was admitted into evidence. Its 4 words, "Don't push me again," remained displayed on the evidence screen for the remainder of the afternoon's testimony, visible to the jury, visible to the gallery, visible to Dillon, who did not look at it. Adana Price's testimony on crime scene staging was methodical and devastating in the precise way that methodical testimony can be when the facts underneath it are clear. She walked the jury through each staging element. The tipped glass with no liquid residue beneath it, the chair knocked in the direction inconsistent with the blood trail, the rinsed knife. She described, for comparative reference, what an unplanned reactive crime scene typically looks like. The differences in blood distribution, the differences in object scatter, the differences in weapon placement that distinguish panic from planning. Then she described what this kitchen looked like. She was careful not to use the word premeditated. That was a legal conclusion for the jury. But she said, "The staging I observed was consistent with an attempt to simulate a different set of events than those supported by the physical evidence." Hale cross-examined her for 90 minutes. He could not move her from this position. She had seen what she had seen, and she had documented what she had found, and documentation does not revise itself under pressure. Kayla Wren took the stand on the 9th day of trial, and it was, by the assessment of everyone present, the most emotionally charged testimony of the proceedings. She was visibly frightened and visibly regretful, and both registers appeared genuine. She confirmed the text messages. She confirmed that Dillon had asked her not to share the 11:44 text. She confirmed that she had deleted the messages and that the digital forensics team had recovered them from her cloud backup. When Chen asked why she had deleted them, Kayla looked at her hands and said, "Because I didn't want to believe what I thought they meant." When Hale cross-examined her, he asked whether Dillon had ever told her explicitly, in clear language, what had happened that night. She said no. He asked whether she was certain the messages meant what the prosecution suggested. She looked up. She looked across the courtroom in the direction of the defense table. She said, "Yes, I'm certain." She said nothing else. It was enough. The recorded phone calls from detention were played for the jury. 14 minutes of audio across 3 separate calls, Dillon's voice emerging from the courtroom speakers with unnerving familiarity. The jurors heard him tell a friend that the police don't have anything real. They heard him say he was not even stressed about it. They heard him orchestrate a public narrative through Marcus Yates. And they heard him say, more in the most damaging recorded passage, "People act like he was some kind of saint. He wasn't. I know what I did, and I know why I did it, and I'm not going to pretend otherwise." It was as close to an admission as recorded conversation had ever come without constituting a full confession. The jury heard every word. The gallery heard every word. And Dillon, at the defense table, watched the speaker on the exhibit table with an expression that had now lost the last trace of its performative evenness. By the end of the prosecution's case in chief, Jennifer Chen had entered 54 exhibits into evidence, and called 14 witnesses, and had built a wall of proof that was, in structural terms, very difficult to dismantle. Richard Hale had done competent and committed work throughout. Dillon's right to vigorous defense had been honored at every turn, and Hale had exploited every legitimate gap the evidence offered. But the evidence was what it was. Now the defense would present its case, and at the center of it would be the decision that Hale and Dillon had debated most intensely across the preceding weeks, whether Dillon would take the stand. It was a decision with enormous stakes in both directions. It was a decision that Dillon, according to Hale's later account, had insisted on making himself, with the same certainty and the same confidence with which he had made every significant decision in this case. He believed he could explain it. He believed that if the jury heard him, the story would change. He would find out, over 5.5 hours in a witness chair, exactly how wrong he was. Richard Hale built his defense on 3 pillars: Dillon's traumatic history with Raymond's earlier behavior, the developmental neuroscience of adolescent decision-making, and a direct challenge to the prosecution's premeditation narrative. He called Dr. Thomas Ackerman back to the stand to elaborate on adolescent brain function, and Ackerman's testimony was substantive and earnest, grounded in legitimate science, and delivered with clarity. He called Sandra as a defense witness, and Sandra testified about Raymond's drinking years with painful, documented specificity, about specific incidents of volatility that Dillon had witnessed as a young child, incidents that the prosecution had acknowledged were real, and that the defense presented as the formative soil of everything that followed. Hale was careful throughout. He didn't ask Sandra to defend what Dillon had done. He asked her to illuminate the context in which Dillon had grown. The jury listened with visible attention. Sandra answered every question with a precision that was clearly the product of many difficult conversations with her own conscience about what she owed each person in this courtroom. The decision about whether Dillon would testify had been, by Hale's post-trial account, the single most contentious strategic decision of the defense. Hale had advised against it, strongly, multiple times, in terms that he said were as unambiguous as he could make them. His reasoning was straightforward. Jennifer Chen had built a case of extraordinary documentary completeness, and Dillon's composure, which the defense had tried to frame as stoicism, would read very differently once it was subjected to direct interrogation under oath. Under oath, the careful management that had served Dillon across months of investigation became something else. The observable inability to answer truthfully without contradiction. Hale knew this. He had told Dillon this. Dillon had overruled him. He believed, Hale said later, that the jury needed to hear him directly. That if he could speak about the history, about the fear, about the years of living with Raymond at his worst, he could change what was going to happen. He was. Hale would say with the quiet gravity of someone who had been proven right in the worst way possible, absolutely certain of it. On direct examination, Dillon was exactly what he believed himself to be: articulate, composed, and strategically sympathetic. He described Raymond's drinking years with specific and credible emotional detail. He described an incident from when he was 8 years old, his father's anger arriving suddenly in a kitchen, the sound of it, on the physical reality of it, that left visible marks on his bedroom doorframe, marks that Sandra had confirmed still existed. He described the experience of living in hypervigilance, of never fully trusting that the stable version of his father was the permanent version. He said that even after Raymond's sobriety, he had never felt safe, that the improved Raymond felt like a performance he was perpetually waiting to see fail. He spoke clearly and maintained eye contact with the jury. Several jurors leaned slightly forward. What Dylan was describing was real. Some version of it was real, rooted in genuine experience. And that was what made the next 5.5 hours so difficult to watch. When Hale asked Dylan to describe the events of the night of Raymond's death, Dylan offered a story of a confrontation that had begun in the hallway, escalated to the kitchen, and ended in what he described as a moment of overwhelming fear in which he had reacted before understanding what was happening. He said he didn't remember every detail. He said the next clear thing he remembered was Raymond on the floor. He said he was terrified and didn't know what to do. It was a practiced account, fluid, internally consistent in its broad shape, emotionally calibrated for the specific audience of 12 people watching from the jury box. And it might have served him better if Jennifer Chen had been a different kind of prosecutor. But Chen had spent months with this evidence. She knew it the way you know a thing that you have lived with, completely, from every angle, including the angles where it broke down. Chen began her cross-examination with a question that was so quiet it seemed almost gentle. Dylan, you said you didn't remember every detail. Can you tell me what you do remember? He elaborated. She listened without interruption. Then she introduced the text message sent at 11:44. Tonight, I finally did something about it. And asked when he had sent it. Dylan said he didn't recall exactly. Chen showed him the timestamp. She asked, if the confrontation in the kitchen happened spontaneously as you described, what had you finally done before you left the house at 11:52? Dylan said he might have been referring to an earlier argument. Chen said, the earlier argument you described occurred on Sunday. This message was sent Monday night. What happened between Sunday and Monday that you finally did something about? Dylan said he wasn't sure. Chen nodded and moved to her next document. She moved to the done message, sent at 2:17 in the morning, and asked Dylan to explain it. Dylan said he couldn't remember sending it. Chen produced his phone records showing 43 other texts from the same evening, none of which Dylan claimed not to remember. She asked, of the 44 messages you sent that night, this is the only one you don't recall. Dylan said he might be confused about that one specifically. Chen said, you sent a message that says done at 2:17 in the morning within the medical examiner's confirmed window of your father's death to the only person you had been confiding in about your feelings toward your father. And you don't remember that one? Dylan said, I may have meant something else. Chen nodded again slowly and said, we'll come back to that. Over 3 hours of cross-examination, Chen walked Dylan through contradiction after contradiction with a patience that the courtroom found almost unbearable to watch and almost impossible to look away from. She asked about the rinsed knife. Dylan said he didn't remember doing that. She asked about the staged glass. Dylan said he didn't know what she was referring to. She asked about the handwritten note. When had he written, "Don't push me again"? And Dylan paused for the longest silence of his testimony. He finally said, "I write things sometimes when I'm upset. It doesn't mean anything." Chen said, "You wrote it on the back of your father's own receipt and left it on the counter 2 feet from where he died. When did you write it?" Dylan did not answer. The courtroom waited. The stenographer's keys were still. Dylan did not answer. Dylan Holt stepped down from the witness stand after 5.5 hours, and what had happened in that time was precisely what his attorney had feared. Dylan's composure, the composure he had offered as proof of innocence, as evidence of a person wrongly suspected, had been made, under oath and under pressure, into evidence of something else. The jury had watched a young man be asked direct questions about the death of his father and respond with uncertainty, redirection, and contradiction. Juror number 7 said later, "When a person who cannot stop managing the narrative tries to manage the narrative under oath, you see it very clearly. It has a specific quality. I recognized the quality." Dylan returned to the defense table. He did not look at his attorney. He did not look at his mother. He looked briefly at the jury, and the jury did not look back. Closing arguments in Commonwealth versus Dylan Holt were scheduled for a Thursday morning, and the courthouse on Elm Street held on that morning the accumulated weight of 7 months of this case. The gallery was arranged in its familiar configurations. Raymond's family on the right, Sandra and her sister on the left, and the press section was full. Outside, the small crowd that had been present throughout the trial was present again. The people who remained, after all this time, were not people who had come for spectacle. They were people for whom this case was personal in some way, who had known Raymond, who had known Dylan, who had children in Harwick Falls schools, who worked in the systems that had produced both the crime and the response to it, and who needed to be present when the last argument was made and the last word was spoken before the jury was asked to decide. Mia and Connor were not present. They had not been at any point during the trial. Their absence was, in its own way, its own kind of testimony. Richard Hale spoke for 91 minutes, and those in the gallery who had watched him work throughout the trial agreed that this was the best 91 minutes of his career. He did not perform emotion. He brought it genuinely to the evidence that warranted it. He spoke about the developmental realities of adolescence with precision and humility. He referenced the documented trauma of Dylan's early childhood with specific and unflinching honesty. He made the jury sit with the moral and scientific complexity of attributing adult premeditation to a 17-year-old's behavior, and he made that complexity real rather than rhetorical. He conceded the physical evidence carefully, acknowledging confusion about the knife, acknowledging poor choices made in panic, acknowledging that this was not a simple case and that he was not asking the jury to pretend it was. He asked them to consider whether first-degree murder required not just proof of the act, but proof of the fully formed adult intent the state had claimed. It was a genuine argument. It deserved a genuine answer. Near the end of his closing, Hale turned toward Dillon and asked the jury to look at him. Not at the evidence, not at the attorneys, at the 17-year-old boy at the defense table. And he said, "This is a boy who grew up afraid, who carried that fear for years without the intervention of any of the systems that were supposed to catch it, who sits in this courtroom today not because he is beyond redemption, but because a series of failures in school, in the mental health system, in the family, reached their terrible conclusion in that kitchen." The gallery was still during these words. Even on the right side of the gallery, where Raymond's co-workers sat, the stillness was not disagreement, but the particular quiet of people sitting with genuine complexity, confronting the fact that the truth of this case could hold multiple painful things simultaneously without resolving any of them. Jennifer Chen rose for her closing argument and did something unexpected. She opened in complete silence. 10 full seconds at the lectern without speaking. The courtroom waited. Then she said, "Raymond Holt made his children lunch. He shoveled his neighbor's driveway without being asked. He wrote his son a letter, 3 drafts, handwritten, apologizing for the man he used to be. That letter was found in his nightstand. His son never responded to it." She paused. "That letter was found in the nightstand of a man who was killed by the person who received it. That is the truth at the center of this case. Not the truth about who Raymond used to be. The truth about who he had become." The gallery received these sentences with the full weight they carried, and several people on the right side of the room lowered their heads. Chen walked the jury through the evidence one final time, not piece by piece, but as a single unified sequence. She described the arc from the handwritten note to the 11:44 text to the 12:09, returned to the done message, to the rinsed knife to the staged scene, to the smirk at the driveway to the phone calls from detention. She described each element not as an isolated fact, but as one step in a sequence that was too deliberate, too consistent, and too architecturally coherent to be explained by panic or trauma or impulse, however real the underlying history might have been. As she said, "The defendant stood in this courtroom and told you he didn't remember. The evidence remembers. The camera remembers. The phone remembers. Your job is to trust what you have seen." In her final passage, Chen addressed the developmental science argument directly and completely. She said, "Defense counsel is right that the adolescent brain is different from the adult brain. Science tells us this, and it is true. But science also tells us that the human capacity to plan, to anticipate consequences, to manage a narrative across days and weeks, as this defendant did, is not blocked by youth. What was blocked here was not cognitive capacity. What was blocked was conscience." She turned briefly toward the defense table. "The evidence tells you that this defendant did not act without thought. He acted with thought and without regret. Pennsylvania law has a name for that, and your job is to say it." She sat down. The room held the weight of both arguments simultaneously, because both had been made with genuine skill and the jury would now have to find the truth between them. In the gallery, during closing arguments, Raymond's sister Diane sat with her eyes closed for much of Chen's summation. Marcus Webb watched the jury rather than the attorneys, studying their faces with the focused attention of someone who has decided that the faces of the 12 are the only thing worth reading now. Sandra sat with her hands flat on her thighs, looking at the floor for most of both closings, occasionally looking up when a specific detail was named. The Sunday argument, the pasta dinner, Connor on the soccer field in the green windbreakers Saturday, and in those upward glances absorbing each detail with the specific expression of someone holding everything in their memory at once and refusing to let any of it go. Judge Calloway gave the jury their instructions at 3:47 in the afternoon. She excused them to deliberate. And in Harwick Falls, for the next 72 hours, the town did what communities do when a jury is out. It waited. Chapter 12. The Verdict. The jury deliberated for 22 hours over 3 days, a duration that attorneys on both sides agreed reflected not confusion, but conscientiousness. Jurors later described significant discussions about the lesser included offences, a genuine debate about the first-degree premeditation standard versus the second-degree malice standard, and the honest, extended work of 12 people taking seriously both the evidence and the law. The retired detective reportedly argued consistently for the first-degree finding based on the totality of the evidence sequence. A juror with a background in social work argued for extended discussion of the abuse history and its mitigating weight. The process, by all accounts, there was real deliberation, not a formality, not a rapid consensus, but the specific, difficult work of people trying to reach a correct conclusion in a case that did not offer simple comfort in either direction. By the end of the second day, the weight of the evidence had settled where the evidence had always pointed. The jury returned on Monday morning at 10:14 with a verdict. The word reached the courthouse before the gallery had fully assembled, and when the last seats filled, every person in the room understood that the next few minutes would end something and begin something else simultaneously. Sandra arrived in a dark coat and took her place. Diane sat across the room holding a tissue she had been holding since she arrived. Marcus Webb was in his construction jacket. The press section was at capacity. Dylan was brought in from the holding area and seated at the defense table, and for the first time in the months of these proceedings, an observer's noted a quality in his bearing that was different from what had come before. Not broken, not collapsed, but faintly cracked, as if something had given way slightly in the area behind the composure. His eyes moved more quickly than usual, tracking from the jury to his attorney to the judge and back. The foreperson, a woman in her 50s, a retired school administrator, rose and read the verdict in a steady, clear voice. The jury found Dylan Holt guilty on 1 count of murder in the first degree. The courtroom processed this in the ways that people process irreversible things. Diane covered her eyes with both hands and exhaled a sound that was equal parts grief and release. Marcus Webb sat completely still, his arms crossed, looking at the floor. Sandra made a sound, small, private, not quite a sob, that belonged entirely to her and to the specific impossibility of her position. At the defense table, Richard Hale placed his hand on Dylan's arm. Dylan was looking at the foreperson, then at the jury, then, slowly, at the ceiling. And in that upward look, something left his face that had been there since the driveway on a Tuesday morning in autumn. The composure did not collapse, but its certainty was gone. The reaction in the gallery was not celebratory, not even from Raymond's family. It was the particular, exhausted release of people who have spent months in the proximity of something terrible and have finally reached the point where the law has named it. Raymond's co-workers on the right side of the gallery shook hands briefly and quietly. Diane wept with her head down. The press section moved with the energy of people who had a story to file and were already doing so. Sandra sat without moving for what felt like a long time, and her sister put an arm around her. And Sandra did not move into it or away from it. She simply sat within it, as if the contact was both necessary and insufficient simultaneously. When she finally stood and left the courtroom, the people in the gallery moved aside to let her pass. Nobody spoke to her. What was there to say that wasn't already in the room? Dylan's reaction to the verdict was, in retrospect, the most revealing moment of the entire proceedings. More revealing than the smirk at the crime scene. More than his testimony, more than the phone calls from detention. Because Dylan Holt, confronted with the full and final weight of accountability, said, according to Richard Hale, in a quiet exchange at the defense table that Hale later described publicly, not, "I'm sorry," and not, "This isn't fair," and not the name of his father. He said, "What do we do now?" Not what happens to me, not what will they do. The question of strategy, the reflex of management. Even in the moment of a first-degree murder verdict, what Dylan reached for was not emotion, but procedure. Not the weight of the thing, but the next move. He had been taught by years of moving through consequence-free environments that there was always a next move. He was about to learn that this was one of the things he had been wrong about. Richard Hale spoke briefly to the press outside the courthouse after the verdict. He thanked his client, expressed respect for the jury's process, and announced that the defense would be exploring all available grounds for appeal. He was measured and professional. He said nothing to suggest the verdict was wrong, only that the legal process would continue in its appropriate course. Inside, this registered as what it was, the statement of a defense attorney who had fought hard for a client and had encountered evidence that was genuinely difficult to overcome. Hale had done his job with integrity. The system had worked. What remained, the question that would now define the case's final and most consequential chapter, was what Judge Calloway would say when she looked at Dylan Holt across the formality of a sentencing hearing 60 days hence, and gave him what she had told him was her job to give. Judge Calloway set the sentencing hearing for 60 days after the verdict. The window allowed time for the preparation of a pre-sentencing investigation report, additional psychological evaluation, and victim impact statements from Raymond's family. It also allowed time for public discussion about what the sentence should be, discussion that was extensive, divided, and often genuinely thoughtful. Because in Pennsylvania, a juvenile tried as an adult for first-degree murder enters a sentencing framework shaped by United States Supreme Court precedent from Miller v. Alabama, which prohibited mandatory life without parole sentences for juvenile offenders. What Calloway would do within that framework was not yet known. Dylan would wait. Raymond's family would wait. The town of Harwick Falls would wait. The judge was not yet finished speaking. The most important thing she had to say was still 60 days away. As Dylan was escorted from the courtroom after the verdict, his path brought him briefly close to the gallery railing on the right side. And for a moment, his route placed him within a few feet of Marcus Webb. The two made eye contact, briefly and accidentally. Dylan looked away first. Webb, in a post-trial interview conducted a week later, described the moment simply. "I just looked at him and thought about Raymond, about how Ray would have taken this, and I think, honestly, Ray would have wept. Not in anger, in sadness, for himself and for his boy." He was quiet for a moment. Because Raymond, right up until the end, was still trying to be his father. He shook his head slowly. That's what I think about." The sentencing hearing was 60 days away. The most important moment of the case was still coming. But it was coming, and this time Dylan would not be able to manage what it meant. The sentencing hearing convened 63 days after the verdict on a Thursday morning in late spring. The courthouse on Elm Street had a different quality by this point in the proceedings. The media presence had thinned. The crowd outside was smaller. But the people who remained were not people who had come for the story. They were the people for whom this was not a story at all. They were Raymond's friends, his sister, his former co-workers, the neighbors who had watched police tape go up at 14 Pendleton Court on a Tuesday morning and had not been able to forget it. The hearing opened at 9:30 with Judge Calloway presiding, and its first order of business was victim impact statements, a phrase that the law has bureaucratized. But that is, in practice, something far rawer and far more essential than its clinical title suggests. These were the voices Raymond had left behind. They were about to speak. The courtroom owed them its full attention. Raymond's older sister, Diane, spoke first. She was 49 years old and had driven 8 hours from Ohio the day before. She spoke for 11 minutes without notes, in the direct, unpolished language of someone who has not prepared a performance but has prepared honesty. As she talked about the Raymond she had grown up with, afraid of thunderstorms until age 11, who had cried at her wedding, who had called her every Sunday evening for the last 4 years. "He called every Sunday," she said, and stopped speaking for a moment, the sentence landing in the room with its full weight. "And one Sunday the phone didn't ring, and I called him and he didn't answer, and I thought, he's probably just busy. He'll call tomorrow." She looked at her hands. He never called tomorrow. He never got a tomorrow." She looked at the bench. "When you sentence that boy, that's what you're sentencing for. A man who never got to call his sister back." Marcus Webb read his statement from a single sheet of paper held in both hands. He was not a man accustomed to public speaking, and his discomfort was visible throughout. but his words were among the most quietly devastating in the hearing. He talked about Raymond's laugh, as about the way Raymond spoke about his children at the job site with pride and hope and a determined optimism that Marcus said he had genuinely envied. He said, "Ray told me once that he thought Dylan was going to be fine, that he just needed more time, that they were getting closer." He folded his paper carefully, as if the care he gave the paper was related to the care he was trying to give Raymond's memory. I didn't say anything. I didn't know what to say. I just hoped Ray was right. He sat down without looking at the defense table. He had said everything he had come to say. Mia and Connor were not present at the hearing. Sandra had made the decision, in consultation with a family therapist, that the courtroom was not a place for her two younger children on this day. Both had written letters, and with the court's permission, those letters were read into the record by the family therapist, Dr. Priya Anand. Mia's letter was 3 pages and addressed in its final paragraph directly to Dylan. "I don't know what you were thinking. I don't know if I can ever understand it. But you took my dad, and you also took my brother. Because the brother I knew wouldn't have done this, so I lost both of them, and I want you to know that." Connor's letter was 5 sentences long. Its final sentence was, "Dad was teaching me how to throw a curveball, and now I have to learn by myself." Dr. Manand read this sentence in a steady voice and then stopped speaking for a moment. The courtroom was completely silent. Sandra Holt spoke last among the family members. She had spent the previous night, she said, writing and discarding versions of what she wanted to say, trying to find a way to hold every true thing at once in language that was inadequate to the task. She stood at the podium and spoke for 22 minutes, and what she said was remarkable in its honesty and its completeness. She did not perform grief, and she did not perform forgiveness, and she did not perform the anger that would have been the easiest and most socially legible emotion available to her. She described Raymond with love and specificity. The pasta dinners, the soccer games, the 3 drafts of the letter, the Sunday phone calls that had begun when he got sober because he wanted to rebuild every relationship he had damaged. She described Dylan, her Dylan, and the child she had held and raised and worried about and failed to protect adequately, with love and heartbreak and the specific, incurable guilt of a parent who will spend the rest of her life asking whether there was a moment she could have changed the course of things. Near the end of her statement, Sandra said something that silenced the room completely. She said, "I am Raymond's widow, and I am Dylan's mother, and I am standing here because both of those things are equally true, and I don't know how to live in that. I have not found a way. I don't know that there is a way, but I'm still here because I have to be. For Mia, for Connor, and because Raymond would have wanted me to be here. He would have wanted me to stand up and say his name. So I'm standing up. And I'm saying his name. Raymond Holt. He was my husband. He was their father. He deserved to finish what he was building." She stepped back from the podium and sat down. The courtroom was silent for several seconds. Marcus Webb, on the right side of the gallery, had his eyes closed. On the left side, Sandra's sister held her hand. Dylan was given the opportunity to address the court before sentencing. He rose and stood at the podium, and for the first time in the long arc of this case, he looked different, smaller. The composure was still present, structural by now. He built into the architecture of his self-presentation, but around its edges there was something new, something observable and real. He spoke for 6 minutes. He said he was sorry. He said it twice. He did not this time say he was sorry about how it looked. He said he was sorry for what he had done. Whether it was genuine remorse arriving finally and late, or whether it was the last performance of a person who had run out of other strategies, the courtroom received it in silence, and nobody claimed to know for certain what it was. Not even the forensic psychologist watching from the gallery, not even the judge. Judge Calloway looked at her papers for a long moment after Dylan sat down. Then she looked at the room itself, not at the attorneys, not at the gallery, but at the room, as if taking its full measure before speaking. She had been on the bench for 14 years. She had heard hundreds of impact statements and sentenced people who frightened her, and people she pitied, and people she genuinely struggled to classify. This case was different, not because it was the worst thing she had seen, but because it contained, within its facts, every question worth asking about youth and violence and accountability and the limits of systems that were designed to prevent both, and had, in this instance, failed. She set down her papers. She looked at Dylan. And what she said next would become the most quoted passage of her judicial career, a passage that a town, and then a region, and then a wider conversation about juvenile justice would repeat and argue about and keep returning to long after the sentence was served. Judge Margaret Calloway began her sentencing remarks by acknowledging what she called the full weight of this case's complexity. She said, "I have read every document in this file. I have reviewed the trial record in its entirety. I have studied the psychological evaluations, all 3 of them. I have read the impact statements, including the letters from 2 children who will grow up without their father. And I have sat with what I know and what I cannot know, because no judge, regardless of experience, can be fully certain about the interior life of any defendant. What I can be certain about is what the evidence shows. And I want to be very clear, before I say anything else, about what the evidence shows." No one in the courtroom moved. The stenographer's hands were poised. In the gallery, Diane had gone still and dry-eyed, the stillness of someone who has decided, finally, to simply bear witness. The judge's voice filled the room with the specific authority of someone who has earned every word she is about to say. The Judge Calloway addressed each element of evidence with the measured precision she had maintained throughout the proceedings. She named the text message sent at 11:44 on the night of Raymond's death. She named the done message at 2:17 in the morning. She named the handwritten note, "Don't push me again," and paused on it with a gravity that the courtroom felt physically. That note, she said, was not written in the chaos of confrontation. It was written before. It was placed on a counter. It was left beside a man's silenced phone. It was, in effect, an announcement of intent, written by a young man who, despite every warning signal that moved through every system around him, was never stopped. She looked briefly at the gallery and then back to her notes. I want those who work in those systems to hear that, not as condemnation, as fact. Because facts are what we must work from, and the work is not finished. Judge Calloway turned directly to Dylan at the defense table. Her voice did not change in tone. It remained measured, deliberate, and the voice of someone who has something specific to say and intends to say it completely. But the directness of her gaze created a gravity in the room that observers described later as unlike anything they had experienced in a courthouse. She said, "Dylan Holt, you are 17 years old. You have experienced things in your life that no child should experience. That is documented, it is real, and it is not dismissed by this court. But the law does not ask me to sentence your childhood. It asks me to sentence your actions. And your actions, the evidence shows, were planned. They were executed. They were followed by attempts to manage, deceive, and contain the truth. And they were followed, most significantly, and by a consistent and documented absence of remorse that this court cannot overlook and will not overlook." Then Judge Calloway said what would become the most quoted passage of her judicial career. She said, "I am aware that some have characterized your behavior during and after this offense as that of someone who believed they were unstoppable, someone who believed that no force, no evidence, and no authority could reach them. I have reviewed your recorded phone calls from detention. I have read the message in which you told a friend that the judge, meaning me, has to give you a break because that's literally her job." She paused. The courtroom held a single collective breath. I want to respond to that directly. My job is not to give you a break. My job is to give you the truth. And the truth is this: actions have weight, and that weight does not disappear because you are young, or confident, or genuinely convinced of your own exception. Now, this court is one of the structures you did not anticipate holding. It is holding. Judge Calloway sentenced Dylan Holt to 25 years to life in a state correctional facility, with a minimum of 25 years before eligibility for parole consideration. Under Miller v. Alabama and its Pennsylvania implementation, she was required to consider youth as a mitigating factor, and her written findings documented that she had done so carefully and completely. She had weighed Dylan's age. She had weighed the developmental evidence. She had weighed the trauma history and the systemic failures and the genuine complexity of what it meant to hold a 17-year-old to the full standard of an adult proceeding. And she had found, on the totality of everything the evidence contained, that the premeditation and the post-offense conduct weighed heavily enough to warrant a sentence at the upper range of the applicable framework. 25 years to life. The words went into the court record. They went into the room. They did not leave. The mandatory psychological intervention component of the sentence was, legal observers noted immediately, the dimension that most clearly expressed Judge Calloway's judicial philosophy. She was not sentencing only to punish or only to confine. she was sentencing to require confrontation. Her written order specified that Dylan participate in a structured therapeutic program addressing emotional regulation, empathy development, and accountability, with his progress documented and submitted to the court annually. She said from the bench, "I am not certain who you can become. Dr. Vance told me honestly that no one can be, but I am certain who you are today, and who you are today is not done growing. 25 years is a long time. I am asking the correctional system to use that time for something more than custody. I am asking it to do what every other system in this defendant's life failed to do: hold the line long enough for something to change." When Judge Calloway finished speaking and the sentence was formally entered into the record, the gallery released what they had been holding. Not in celebration. There was no celebration, but in the specific, exhausted exhale of people who have been carrying something for a very long time and have finally been permitted to set it down. Diane covered her eyes. Marcus Webb nodded once, slowly, at the floor. Sandra sat with her hands pressed flat against her thighs, eyes forward, face holding everything. Dylan was escorted from the courtroom by 2 officers. Richard Hale placed his hand briefly on his client's shoulder before the escort completed. The bailiff called order, though order already prevailed. Outside on the courthouse steps, one of the Justice for Raymond signs was lowered slowly by the person who had been holding it. Not dropped, or not thrown, but lowered with the deliberate care of someone completing something. Several hours after the sentencing, Patricia Nguyen stood on her front porch at 14 Pendleton Court's sightline and spoke to a journalist. She was asked how she felt. She thought about it. She said, "I think about Raymond shoveling my driveway, just doing it without being asked, just because it needed to be done." She looked at the empty driveway across the street, and where a police cruiser had sat 8 months before, lights turning cold against warm siding. "And I think about that boy standing there that morning, with that look on his face." She paused. He thought he was standing at the end of something. He was standing at the beginning of something he didn't expect. She went inside. Patricia Nguyen's camera kept recording. The driveway stayed empty. Somewhere in a correctional facility in western Pennsylvania, a 25-year clock had begun to run. And in Courtroom 4 in Harwick Falls, the truth, stubborn and unmanageable, and finally spoken aloud, had done what truth always does when it is given enough room and enough time. It stayed. In the weeks following the sentencing of Dylan Holt, the town of Harwick Falls began the slow, imperfect work of returning to itself. The courthouse on Elm Street reverted to its ordinary docket. The press left. The flowers and candles at the end of Pendleton Court's driveway were gradually replaced by the ordinary accumulation of neighborhood life. A soccer ball in the gutter, a recycling bin left at the curb, a child's lost glove on the sidewalk. Sandra sold the house 6 months after the sentencing and moved with Mia and Connor to a smaller town 40 miles north, near her parents, in a place where the address did not mean anything to anyone. She did not speak publicly about the case for more than a year, and when she finally did, in a brief interview with a regional magazine, She chose her words with the precision of someone who had spent a long time deciding what was hers to say. We are trying, all three of us. We are just trying. It was the truest thing anyone said about the aftermath. Marcus Webb and several members of Raymond's crew established a scholarship in Raymond's name at Harwick Falls High School, $50 a year, given to a student who demonstrated what the application criteria described as genuine improvement and persistence. It was not a large scholarship. Raymond would have found the sentiment embarrassing, Marcus said. That was just how Raymond was about recognition. He didn't want acknowledgement for the things he did. He just wanted to do them. But the scholarship existed, and it bore his name, and every year a student received it and a check was cut, and someone in a room said Raymond Holt's name out loud, said it in the context of something forward-looking, said it in connection with a young person who was trying. Raymond had spent the last 6 years of his life trying. It seemed right that his name should be associated with that word. In the aftermath of the case, the Harwick Falls Unified School District reviewed and revised its student concern reporting protocol. The revision was quiet and administrative. It did not make headlines, but it was real, and it mattered. It added a mandatory escalation requirement for any documented student statement referencing intent to harm, requiring review by both the building principal and a district-level counselor within 48 hours. The revision was prompted directly by the Holt case. Mr. Gerald Cam, the teacher who had filed the concern report 2 years before Raymond's death, the report that had been logged and then forgotten, submitted a public comment during the review process. He wrote, "I reported what I heard because I was afraid of what it might mean. I trusted the system to do the rest. That trust was misplaced. It cannot be misplaced again." It was one paragraph. It was the most important paragraph in the entire review document. Dr. Serena Vance published an article in a forensic psychology journal 8 months after the sentencing, examining what she called the compounding effect of sequential system failures in juvenile cases with pre-offense behavioral signals. She did not name the Holt case explicitly, professional ethics prohibiting it, but her descriptions were unmistakable to anyone who had followed the proceedings closely. She wrote about the gap between the identification of risk and the actualization of intervention, and about the way that gap, in school, at home, in the mental health referral chain, can function as a permission structure, reinforcing in a vulnerable young person the belief that their behavior exists outside the reach of consequence. She concluded with a sentence that was quoted widely in legal and psychological circles in the months that followed. We build warning systems. We must also build response systems. The difference between the two is the distance between a flag and an action. Raymond Holt, in his worst interpretation, was the action that a flag failed to prevent. Dylan Holt was transferred to a state correctional facility in western Pennsylvania, where he was enrolled in the structured psychological intervention program mandated by Judge Calloway's sentencing order. Annual reports from the facility be available through the Department of Corrections review process indicated that Dylan participated in the program regularly and that his engagement was described in the clinical language of correctional psychology as variable but present, meaning he was neither resistant nor yet fully arrived at the place the program was designed to bring him. One annual review noted that he was demonstrating early-stage acknowledgement of harm, and with limited effective integration. In ordinary language, he was beginning to understand what he had done. The gap between understanding it and feeling its full weight, between the intellectual and the emotional reckoning, was a gap that 25 years might or might not close. No one could know. Not Dr. Vance, not Judge Calloway, not Dylan himself, not yet. Mia Holt turned 16 in the fall after Raymond's death and joined her new school's soccer team, and, according to Sandra, I found something of Raymond in the game, in the way it asked you to keep moving, to keep trying, to keep showing up for your teammates regardless of the score. Connor, who had been 9 years old when his father was killed, continued to grow up in the careful and loving presence of his mother and his grandparents, and the long, careful memory of a man he would have to reconstruct from photographs and stories, and a green windbreaker that Sandra kept in the closet of the new house. And he learned to throw a curveball eventually. His grandfather taught him in a backyard 2 counties from Pendleton Court on a Saturday afternoon in a season Raymond never saw. Connor threw it well the first time he got the grip right, a clean, arcing curve that broke exactly where it was supposed to break. His grandfather caught it and smiled. Raymond would have cheered loudly enough for the whole street to hear. He would have been so proud. But he would have called Marcus Webb on the way home just to say it. In a judicial ethics seminar several months after the sentencing, Judge Margaret Calloway was asked whether she felt she had made the right decision in the Holt case. She paused for a long moment, the kind of pause that communicates that the question is being taken seriously rather than deflected. She said, "I made the decision the evidence and the law required." Whether it was the right decision in the deepest sense, the human sense, is something I will never be fully certain of. I am certain that Raymond Holt deserved to be named in that courtroom. I am certain that his death deserved to be treated as what it was. I am certain that Dylan Holt needed to encounter a consequence large enough to break through whatever it was that had insulated him from reality for 17 years. She paused again. Whether 25 years is that consequence? She stopped. She looked at her hands. I hope it is. I can only hope. This is what justice looks like in the real world. Not clean, not simple, not the tidy resolution of a moral fable where the right verdict arrives, and the grief resolves, and everything that was broken is repaired. It looks like a mother who is also a widow, trying to raise 2 children in the long shadow of a day that cannot be undone. It looks like a scholarship for $50 given in a dead man's name, year after year, to a student who is trying. It looks like a teacher's comment in an administrative review and a protocol that most people will never read, but that might, one day, in some school, on some ordinary afternoon, catch something before it becomes irreversible. It looks like a boy in a correctional facility who is beginning, at long last, to sit with what he has done. Sitting in the slow and painful way that genuine reckoning works when it finally arrives. And at the center of all of it, like the still point around which everything else turns, a man who shoveled his neighbor's driveway. A man who wrote 3 drafts of a letter. A man who sat at a kitchen table on a Saturday morning with his youngest son in his lap, reading the newspaper in a house he had built with his own hands, and not knowing that someone nearby was watching, and had decided that this piece was something to be ended rather than joined. The gavel fell. The smirk disappeared. And in courtroom 4 in Harwick Falls, Pennsylvania, the truth, stubborn and unmanageable, and finally spoken into the record, did what truth always does when it is given room and given time and given a judge who understands what her job actually is. It stayed. If you believe that accountability matters, that Raymond Holt's life deserved more than a driveway and a case number, share this story. Every voice that says this matters keeps it from being forgotten.